to Nevada Legal Services Now. I am Ray Gertkin, the directing attorney of the Reno office of Nevada Legal Services.
And I'm Dolshan.
You still haven't changed your name.
I know, I don't know how. I do have all these books that I've read.
And then I'm Ashley Cummins, staff attorney in the Reno office.
And we're going to just try to talk a little bit about the current status of PUA benefits, along with some regular UI benefit issues, and kind of talk about what those issues are, and really at the end talk about what you can do about them. All right, so first, just to kind of start with regular UI eligibility, and we're going to be using the terms UI and PUA. Just remember, UI is unemployment benefit, unemployment insurance benefit, sorry, and then PUA is pandemic unemployment assistance. So, originally when the coronavirus issue started, one of the biggest questions we got with respect to regular UI eligibility was whether or not somebody could quit or refuse to go back to work if they were afraid of essentially contracting coronavirus. We saw from the Department of Labor regulations with respect to PUA eligibility that if a doctor required you to quarantine because of, your health, if you had a compromised immune system, then that was part of the PUA eligibility, that if you were unable or unavailable to work because a doctor advised you to quarantine because of the risk of contracting coronavirus, then that was essentially the good cause. But that doesn't address the issue where you don't have a doctor that's told you that you can quarantine. So, we have had some positive results from appeals hearings where individuals with compromised immune systems were in fear of contracting coronavirus, certainly if the employer is not following OSHA or CDC safety guidelines. But other than that, we're still it's still an open question whether or not, the employer not following the safety guidelines is enough, especially if you haven't reported the employer. So I still think, in terms of the good cause to quit framework, you still need to go through a little bit of the due diligence in the sense that you've addressed the issue with your employer. It is a compelling reason, meaning you have that compromised immune system. They're not taking steps to protect you from getting coronavirus, but also that, you've gone up the chain, so to speak, and reported and tried to get your employer to comply. But then there was the advent of the SB3 and the refusal of suitable work. David, do you want to kind of give an overview of the SB3 sort of issue, that's its current status, I guess?
Right. The current status of Senate Bill 3, it was passed by the legislature and signed by Governor Sisolak. It does allow people to refuse work if it's based on a fear of COVID, if it's related to COVID. Unfortunately, it requires the Employment Security Division to promulgate rules, and that hasn't been done yet. So there really is no protection. You could say it's a law that hasn't been enacted yet. Whether you can use that currently to refuse work and still qualify for regular unemployment, I don't think you can. You have to read the plain reading of the statute, and it does require regulations by the Employment Security Division, and they haven't done that yet.
So SB3 might be helpful in the future, but now you're just going off of the intent of the legislature without the regulations.
That's basically it.
Okay. And then finally, before we switch and really kind of concentrate more on PUA benefits and what we're seeing now, is an issue that we've also seen coming up where someone is eligible for regular unemployment benefits because the employer shut down, there were layoffs, whatever it was. And now we see a lot of employees returning to work. So then the issue is an employee with a compromised immune system gets a notice, gets the letter from the doctor saying they should not return to work. They need more time, whatever it is, masks, protocols, whatever. So then there's that transition between they're not, eligible for regular unemployment benefits, but then because they can't return to work, they're no longer able and available, but they're specifically eligible for PUA benefits. So the issue that, we've kind of been trying to work through, although I don't have an answer for this yet, is what is then required of the employee. Are they going to be required to apply, reapply, for a separate application process for PUA? That's kind of the modus operandi of ESD, is they're making everyone file separate applications depending on the eligibility under the certain programs. And they're not evaluating people. But because you're still technically eligible under PUI, I think there's an argument that the benefit shouldn't stop because of it. So, we're in the early stages of this. There have been a couple of instances where this has come up. And it has not so far that we're aware of been resolved by either the UI system, PUA, or just, ESD in general.
And I'm a little groggy, but I think you said PUI, so.
PUA. I hope I said PUA anyway.
That'd be a new feature, right?
All right, so as I said, we're really going to focus the rest of this presentation on PUA benefits. And please remember, if you have any questions, put them in the comments to the video. We are monitoring them, and we'll try to address any questions that you have in real time. But PUA eligibility, this is the baseline for PUA eligibility. Hopefully most people are familiar with this, but if not, we'll go ahead and just give you a little bit of background when PUA was initiated. So first thing is that you cannot be eligible for regular unemployment, which is UI. Hopefully I'm making the distinction between UI and PUA. But essentially, if you're eligible for regular unemployment benefits, and that means at any level, if you're eligible for $100 in regular UI, you are not eligible for PUA. So that's the first hurdle, is you cannot be eligible for regular unemployment benefits. One thing, though, that we have been also getting some questions about is if you're ineligible for UI because they've determined you to be ineligible because you had an issue with a former employer for quitting without good cause, or maybe being terminated for misconduct. David, do you want to kind of talk about the status of that issue in terms of the Department of Labor regulations?
Well, so I can talk about an actual case that I had where somebody wouldn't return to work because they were taking care of someone, and it wasn't really related to COVID. So the question was that good cause to quit? And that's probably not. Probably not. But what happened is he then applied for another job, and that job shut down because of COVID. So yes, he would be eligible for PUA, even though he had that previous disqualification for regular unemployment. So they can be related. And if the reason you're unemployed is because of misconduct, then you're not going to be eligible for PUA. But if there's that break, if you can establish that you're out of work because of COVID, then you would be eligible, even though you may have committed misconduct or refused to work, or one of those other for-cause reasons for not getting regular unemployment.
Right. And the Department of Labor actually came out with regulations that kind of said that.
Right.
So it shouldn't be an issue of that. You do have to be independently eligible for PUA, as David said. I probably didn't make
Right.
that
And that's why had work is kind of emphasized here, because if you were out of work prior to the COVID crisis and not working, then you're not going to be eligible for PUA because you weren't idle because of PUA. You were idle before that. So that's another sort of subtlety here, is that, it's not just being unemployed, but being unemployed because of COVID.
Right. And then the one other thing just to highlight is they do make a big deal about fraud. So if your issue with regular UI eligibility has anything to do with fraud, you're probably not going to be eligible for PUA.
And we did just get kind of a question. It says, I'm still awaiting payment because of an investigation of an old overpayment where UI received 2 garnishment payments after my last day of work on March 12, 2020. I guess that's kind of tough. I mean, we have seen cases, right, where it will say like issue delaying payment under investigation or something like that. And it says,
I guess I'm not sure I understand the garnishment issue. What why the garnishment payments were an issue, but if they're, if you are determined to be ineligible for UI for a
Right.
reason unrelated to fraud, but potentially eligible for PUA because you do qualify under these guidelines that we're talking about, that you had work, but were out of work because of a coronavirus related reason, then you could be eligible for PUA and may want to consider applying for PUA.
We're getting a couple more in.
Well, I
Sorry,
think
David,
that
go
needs a
ahead.
little clarification. And I admit that I didn't really understand what you were saying, Ray. But if there is an overpayment for regular unemployment and you were idle because of COVID, you could be eligible for PUA. Is that what you?
Yeah, that's basically what I said, but probably a long-winded way of saying it. I
Sounds
guess my
good.
point, and this might have been confusing because I'm just not sure what the two garnishments had to do with the question. So if you have clarification about that, maybe we can address that separately.
But that person, yeah, should apply for PUA if they were out of work because of the
Coronavirus. Right.
Then another one says, I read something that you had to make $100, I'm assuming, a week to collect plus supplement my income because I'm on Social Security and was laid off due to COVID.
Well, there is a minimum benefit amount. I will say that. If we're talking specifically about PUA, the minimum benefit amount is like 119 or something dollars. You do have to make a certain amount to be eligible for benefits. It is based on it's called a benefit year and then a base period. So you do have to have a certain number of base period wages in order to qualify for benefits. So if you don't have that, then technically you're not eligible for regular UI. Now, the issue, we're not talking about this right now because the $600 has gone away. But there would be a question about whether or not, the PUA, I don't know. I think it depends on what we're actually talking about. If you're talking about you don't have wages to support a regular UI claim, but have self-employment income. But if you had like very, very little income, it's possible you might not qualify.
Right, you won't qualify for regular unemployment, nor will you qualify for a PUA because technically you're not idle because of the pandemic. Now, let's talk just a little bit, the Lost Wages Assistance Program. Apparently Nevada has applied for that extra $300, so it's not available, but maybe it will be in the future.
Yeah, I understand. And I do apologize. I did see that we were applying for it, but I also understand that we're not potentially kicking in the extra 100 or the additional 100. So yeah, we'll have to keep an eye on that.
We have another question. What if an employee had a doctor's note to stay out of work due to waiting for COVID results and then was terminated upon returning to work once it was determined that they were not contagious? Would they qualify?
Okay. So yes, if you had a doctor's note or some reason, coronavirus related reason that you couldn't return to work, then you're potentially eligible for PUA. If you were go back and are fired because of why?
It didn't say. It just said then was terminated upon returning to work once it was determined that they were not contagious.
Okay, that doesn't make any sense. That might be more of an employment wrongful termination issue. But yeah, as long as you don't commit misconduct, or you didn't commit fraud, then yeah, you're potentially eligible for coronavirus or for PUA because that appears to be coronavirus related.
Then we have, I was denied UI, applied for PUA, then a letter was sent saying I needed to apply for PEUC or SEB. Are you familiar with these?
Yeah, so that's the extended unemployment benefits. So the federal government and the state government have initiated extended unemployment benefits that trigger, well, I'll just put it this way, PUC has been triggered. So if you were receiving regular UI, you should have just been eligible for PUC. That is considered regular UI benefits. So you would be not eligible for PUA if you could continue receiving extended unemployment benefits. And SEB is state extended benefits, which are triggered by the percentage of unemployed individuals in the state. So that does mean that you're not eligible for PUA if you are eligible to continue receiving the extended unemployment benefits.
Why wouldn't the Employment Security Division just do that for you?
They should. I know that they're doing intervening eligibility examinations. So they are re-examining eligibility before approving the PEUC, the extended unemployment claims. So there is that, but technically speaking, if you're eligible for extended unemployment, you are not eligible for PUA.
And then this question's kind of, I'm trying to figure out what they're trying to ask, but it was, I already qualified for the benefits and was already collecting. So does that make me eligible because I am still collecting unemployment at this time? I'm currently collecting unemployment right now, and I'm getting the $42 a week right now. The question I'm asking is, will I qualify for the additional 300?
I mean, assuming that that is approved, then, you know, we're anticipating it acts just like the additional 600 did.
Right.
But it hasn't been approved yet.
Okay. And then, sorry,
David.
Does that only apply to I don't even know if it only applies to PUA, so I shouldn't even mention it.
I thought it applied to everything, but
yeah, no, I would think
there
so.
was a question, it just got redacted, but I do think it's still a good question. It was asking if they'd be eligible for PUA if they're taking care of kids when the schools are closed.
The schools aren't closed, but I guess they are. Yeah, Clark County School District is telelearning, so yeah, no, that would be one of the reasons.
I guess, sorry, I just received a clarification. I apologize. I was looking at another screen regarding the lost. I think we're talking about the lost wages assistance program. You do have to have $100 in benefits, allegedly. So if you don't have $100 in weekly benefits, you're not eligible for the additional assistance. So if you are getting $100, less than $100 from unemployment right now, you may not be eligible for the additional 300 if that gets approved. Okay. Sorry, I interrupted, but I just want to make that clarification.
No, that's good.
But also, if you're taking care of a child who cannot go to school because of COVID, then that is a reason to collect PUA.
Perfect. Then we have a final kind of circle back to the question regarding the employee who left for 2 weeks to get tested for COVID and got a negative result. It was just that the employee was told they were no longer needed. So I think that ties right back into what you were talking about, where as long as you were not terminated for misconduct, then yeah, it should go ahead and apply.
Yeah, if you were just additionally let go, then yes, that is eligibility for these programs.
Okay. That is it for everything that is up right now. But like Ray said, I am monitoring the questions. So if you guys have any, don't hesitate to ask them.
And I could point out too that the reason we highlight substantially interfered is because that is the standard from the lawsuit in the PUA case in Reno. The Department of Labor interfered with diminution. So the point is, you don't need a complete shutdown of the job. You just need a substantial diminution or interference to qualify for PUA.
All right. So now we're going to kind of address, obviously we've heard about some common issues already. We are going to address some other issues that we have been hearing about. So we have a lot of individuals that are still in this, we call it the black hole, the dark period, the waiting period, where you've applied, but you have not received anything, like no benefits, no determination that you're ineligible, just nothing. We're going to talk a little bit more later on about what you can do about this, but obviously there are some highlights underneath all of the issues that we'll address later on. The next that we've been seeing a lot of are people who have been determined to be eligible, payment has been made, but then stops. This is also a big problem, especially for people who have applied for PUA. There is, I do address this in another slide, so I might just mention that there have been a lot of people getting notices that they should be eligible for UI now. Like I said, we'll talk about that more, but that's been a common issue because there have been tens of thousands of notices that have gone out, and there's no guarantee that those notices are correct. If you're eligible for regular unemployment, but you applied for PUA and you got unemployment benefits and didn't realize it, you can ask to waive an overpayment as long as it's not based on fraud. You're not at fault, and recovery would be against equity and good conscience.
That's simply caused by the two systems, the two application systems that should be one. There's no reason why they're not one, but of course it relates to the incompetence at the Employment Security Division that they created too. I mean,
and then, oh, sorry, go ahead.
No, that's all right. All right.
And then I kind of talked about this, you're eligible for regular unemployment benefits, but can't return to work. So you're technically eligible for PUA. How is that getting handled? Unfortunately, that is one issue I don't really have an answer for right now.
The eligibility.
Yeah, how they're handling it. Are they going to make people apply for PUA? Just, evaluate them because they're eligible for PUA, how that ends up working. But, benefits shouldn't stop. So, that is another issue.
Right. I mean, if the reason you're out of work is because of COVID and you run out of regular unemployment, you should be switched over to PUA. Unfortunately, you probably have to go online and apply, and that's the basic problem.
Right.
We do have a question. I applied March 29th for UI, and then in June was denied for UI and applied and was denied for PUA. But was advised to apply for UI, which is now pending as other with nothing stated since. And the question is, do I have a good chance of getting back paid to the original closing date of March 19th?
I would say the first denial, if you don't appeal within 11 days, that's gone. Is that what happened?
Yeah. It sounds like
she. I'm just not sure if they were initially applied for regular UI, were determined to be ineligible, applied for PUA, but I guess they're saying that they had additional work in 2020. So
yeah, it says, but was advised to apply for UI. So I'm assuming the denial from PUA said what we often see it, where it says you were denied because we found that you are eligible.
Yeah, appeal that PUA decision. That's the bottom line. Is appeal that PUA decision no matter what you do with respect to the UI eligibility, because you do want to preserve your application, your claim dates, essentially.
Right.
So I would appeal that PUA decision because, and we're going to get to this issue in the next slide, but I think they're sending out notices that people are eligible for regular unemployment benefits, but not actually determining that the individual is actually eligible. So those notices that are going out saying you're eligible for regular unemployment benefits, even though you've applied for PUA, are not necessarily geared towards you. They are mass mailings that I don't think that ESD has done due diligence. And let's address that when I get to the slide so I can develop it comprehensively.
Ray, you might want to check your microphone because your volume went way down.
Okay, sorry. Well, let's go on because I will address that question.
Okay, so we got a couple other questions coming in, but
can we get through this and then I want to address that other question, then we'll get to them. So perfect. The other common issue that we're seeing are fraud issues, that people are being alleged to have committed fraud, but it's for silly issues like you use a friend's computer to apply, you transpose a phone number or social security number. These investigations are taking a lot of time, and obviously people can't reach the investigators by phone. We have been advising people to just upload all of their identifying documents or a statement regarding like, I used my friend's computer. We have seen this potentially expedite the process. Now, I do understand that there have been massive data breaches with this information, and people uploading information, identifying information to the portal can be frightening and an issue. But we have been seeing where uploading, at least a statement, some explanation regarding the alleged fraud has been helpful if you upload it to your portal. All right, so this is what I was talking about, this PUA UI eligibility. So, and I forget, there was in the special master's report from the Washoe County lawsuit, there was an indication that 50,000, I think, or something, there's mass mailings of notices to individuals who have applied for PUA that say that they have UI eligibility due to the new potential quarters of coverage. They're relying on their contractor, Geographical Solutions, to do so. I have no faith that this is being done correctly. It appears to be a blanket notice just to speed up the eligibility process. I don't know that I think that there's a guarantee that this is based on accurate information. If you did work though in 2020, you could potentially have new earnings, which mean you might be eligible for a new base period under the regular UI system. So there is a potential that this is correct, but I'm aware that there are people who are getting these notices and have zero new income in 2020 because they are still laid off because of coronavirus. So that means that this notice was sent out in error, essentially. So if you apply for PUA, you don't, it's clear or questionable that you don't have additional UI eligibility. You absolutely want to appeal that PUA determination so that you save your claim date. I don't know, as David said, if you didn't appeal the original UI denial, that you can preserve that claim date. But if they're saying you are eligible because of a new quarter of coverage, I do think there's an argument that, you should be able to go back to that new, whatever that the first date, obviously, we're talking about like April 1st. July 1st. Those are new quarters of coverage. That if you had income that would support a regular UI claim in 2020, it is possible that you only have UI eligibility at that point in time. Because remember, with PUA, you have to be ineligible for UI in order, no matter what your benefit amount is, you have to be ineligible for regular unemployment benefits to be eligible for PUA.
And there's a follow-up question with the same fact pattern, and it's how do you go about filing the appeal?
So PUA appeals are online now. There is a link in the online portal. If you go to the appeals information, you'll see there's some, dates. And then if you scroll down a little further, there's like notices of determination. So if there was a notice that was issued to you determining that you had other eligibility, there's a link that you click on right next to that document and allows you to file your appeal. But you have to do that online.
And is there an option with PUA appeals if you've missed the appeal deadline? Is there any option for you?
I mean, I would argue good cause. I mean, you have good cause normally to argue for late appeals. So I think
they're late with their appeal process. So
yeah, I mean, you couldn't even appeal until July 24th. People are, they're telling people they'll respond within 7 to 10 days. That's not happening. Now the story is that they won't schedule any of these appeals until late September. So I think, get a good statement together why you have good cause to appeal late. Especially if it's, you told me I was eligible for another program. I didn't realize I should appeal this. Whatever you can come up with to argue good cause, you will want to do that once you file your appeal.
And then we have a follow-up question regarding the kind of garnishment issue. He said he's filing every week and gets a confirmation each week that the claim has been accepted but has not been paid because of the 2 garnishment payments back to UI, and that the overpayment is from 5 years ago. So I'm wondering if it's like
they're collecting the overpayment out of your unemployment benefits, which they are allowed to do.
Yeah.
You have to ask for a waiver of the overpayment for that to stop.
And then question, I did receive benefits starting February 2nd, but many missing weeks were not offered to me during weekly filing. Nothing changed with my situation anyway. So why did those weeks get skipped over?
In the online unemployment portals, both for PUA and regular UI, obviously for PUA because it's all online, but for regular UI, there should be next to every week that you filed a claim, you can click on it to see why, if it was paid, the reason why it wasn't paid. And it's going to depend on what that says. If it's something like, they're determining whether there was a severance or you were really unemployed during that week, it should have some indication of that. Without further information about what the denial actually was for, it would be hard to answer that question, but you should be able to investigate that in your online portal and click on the links to see why they're saying there's an eligibility issue with respect to that payment. Now, if there's a notice of determination that says you're ineligible for any given week you receive unemployment benefits, you have to appeal that decision if you disagree with that determination. And you have to do so within 11 days.
Okay, that's it for all of the questions right now.
All right, so as I said, kind of sort of earlier, sort of the point of this is to not only identify the potential issues, but really talk about at this point, what can you do about it? So I'll turn it over to David to discuss this, but we're going to start with the lawsuit in Washoe County.
So the lawsuit in Washoe County, we received word today from Ray that the Supreme Court appeal was rejected. So we really don't know what the status is. We do know that on, I believe, September 10th, there will be this contempt hearing to see if the Employment Security Division should be held in contempt, because the judge did order the Employment Security Division to do several things that are on this list. They had to do those by July 28th, and they haven't. First of all, the fraud allegations, there were 31,000 initially, and there's still 22,000, so they haven't really done much. And the judge said you should pay people unless there's no weekly claim filings, you're not eligible for regular unemployment, and there's not sort of clear and convincing evidence of fraud. So that would pretty much apply to those 22,000, but they haven't been processed yet. You switched? Okay.
Sorry.
So the other thing that is a problem, and it's based on ESD's incompetence, is the two-tiered system of regular unemployment applications and PUA applications. What the Employment Security Division was doing is if you were waiting for regular unemployment and they determined you weren't eligible, you had to go to the back of the line of the PUA application process. So the judge said that's totally unfair. And of course it is unfair. Any reasonable person would know that, but apparently the Employment Security Division didn't know that. So the judge ordered that. That's still going on, and the Employment Security Division isn't really paying any attention to the court's order. The judge did order the backdating of claims before the Employment Security Division wasn't applying it before the state of emergency, and the CARES Act does require February 29th, so you can backdate those claims all the way back to February 29th. Also, you don't wait a week under the CARES Act. I believe under regular unemployment, Governor Sisolak's directive has expired. I don't know, but under the CARES Act and PUA, you don't wait a week for your benefits. Also, the Employment Security Division should continue to pay benefits if it was initially determined that they were eligible. And apparently that's not happening. So the state of Nevada, the Employment Security Division, and the plaintiffs will be back in court on September 10th. The problem is that this is not a class action. It's not certified, so you can't really enforce these provisions. It really is basically the Employment Security Division trying to save face and act in good faith, which should be in quotes because they're not really complying with what the judge ordered.
We have a couple questions coming in. One is about still kind of the overpayment issue. And the question is, how do you get a waiver for the garnishments? I'm assuming in this case, it means for when ESD is taking your benefits to cover an overpayment.
So as we said before, NRS 612.365, you can request a waiver of an overpayment. Basically, you want to submit a request for the overpayment waiver and allege that, how this would be against equity and good conscience, that it wasn't based on fraud, and that you were without fault. Well,
but you have to do that when you get the notice of the overpayment.
I think you can request the overpayment at any time, a waiver of the overpayment at any time. I mean, if we're analogizing, I haven't seen a deadline on that to request the waiver of the overpayment. I mean, I know in Social Security, there's no deadline. We can check NRS 612.365 to verify that before the end of the presentation as well.
And then this is circling back to the question of the overpayment, the one we've been talking about. It says, I've talked to BPC, and they said my overpayment was old and went away because of a law change in July 12, 2020, and that I should be getting paid, but not because of those two payments. Yeah.
I'm not aware of a law change on July 12th. David?
Maybe it's SB3. I think there's a lot of particulars here, and
I think that I would encourage you to call one of our offices to see if
yeah.
maybe, because I still don't understand the issue with why those two garnishments would be a problem. I apologize. This is not really a good forum to kind of delve in depth into people's issues.
Yeah. Then we have my account was closed for a fraud issue in quotes. I was told it was resolved and my benefits would resume 2 to 7 days. It's been weeks and I still can't access my funds. What do I do?
So we were going to talk about that. So let's go back to that question. All right. So we've kind of been talking on the previous slides about a writ of mandamus. So David, do you want to explain what a writ of mandamus is and sort of what you need to have in order to file one?
So a writ of mandamus is basically available if you don't have the ability to file a petition for judicial review, which is what you normally have when you're denied unemployment benefits. If you don't have the ability to file a complaint because there's really no agency action, nothing you can get your hands on, then you have the right, no adequate remedy at law, you have the right to file a writ of mandamus. Now, a writ of mandamus is allowed when a state agency has a statutory duty or some duty to do something under the law and they're not doing it. And so a court can come in and say, state agency, you have to do this because that's what the law requires. So in this situation here, we're going to be arguing that under the CARES Act or under regular unemployment, NRS Chapter 612, the Employment Security Division has a statutory obligation to dispense regular unemployment or PUA. They're not doing that. There's no right to appeal because your appeal has been transferred to the supermassive black hole. So you're stuck. And when you're stuck like that, you do have the ability to file a writ of mandamus.
Right. And so, specifically with the writ of filing a petition for writ of mandamus, one of the original time frames we're looking at is there's a Supreme Court case that basically says administratively feasible for payment of benefits is 7 weeks. And so anybody who's essentially been waiting longer than 7 weeks for their benefits might, if they have not been denied or haven't received an appeal, what is it that you do? There is no, remedy at law.
Yes, the Java case, it's cited in the PUA lawsuit. The Department of Labor abides by it. So it is fairly safe to rely on that case. And the 7-week time frame, strictly speaking, in the Java case applied to the application for benefits and either the disbursement of benefits or a hearing. So if it's taking longer than 7 weeks, then it possibly could violate due process of law, and you would have the law to enforce against the Employment Security Division and the ability to file a writ of mandamus.
Nope. So that's basically it. We will obviously be taking additional questions. I want to circle back to the waiver issue really quickly. I did just pull up NRS 612-365. I do not believe that there's a limit on when you can request the waiver, but you do have to appeal the denial within 11 days. I mean, I don't know. Subsection 7, any person against whom liability is determined under this section may appeal therefrom within 11 days after the date the notice provided for in this section was mailed to the person. I mean, I guess if you received a notice that you had an overpayment, you could appeal that within 11 days. I don't know if that means that you can then ask for a waiver and then appeal that within 11 days.
Yeah, I know I've heard of people asking for waivers past the 11 days, but I guess I haven't heard of any.
There's no harm in trying. I'll just say that. if there's an issue where your waiver request was denied because you didn't request it within 11 days of the notice of overpayment, I mean, we can do a more, detailed analysis of NRS 612-365 to see whether or not there's actually a requirement that you request the waiver within 11 days, or if the 11 days is simply on the appeal of a denial.
And if we want to complete the circle, I would just say if people are frustrated and waiting and feel the strike force has struck out and the PUA lawsuit has been slowed to a snail's pace, then people should consider contacting our office and filing a writ of mandamus, because there has to be something done. And if they're going to start hearings in late September or mid-September for PUA denials, that's totally unreasonable. And the fact that we're talking about it without crying or shouting indicates that we've accepted this slow pace, and we shouldn't accept it. I mean, these are emergency benefits that were created at the end of March of this year, and they're still not available to many people, hundreds of thousands of people in the state of Nevada.
Yeah, we actually just got a question coming in that says, has anyone, in all capital letters, had any luck contacting a human at Employee NV? I've tried email, messaging, appeals, and phone calling. Do I have to go down to the office to speak to a human? I think it ties into exactly what you were talking about with the frustration. And just kind of like what David just said, if there's nothing going on, you haven't received any notices, you haven't received your benefits, do feel free to give our office a call. And it's something we can take a look at to see if potentially you would be, your case we could file a writ for.
And I would say going down there is not the answer. I think
no.
A good chance you'll get arrested or hassled. That's a volatile situation. And yes, we have had clients, especially recently, who have reached someone live, and it's quite refreshing. It's quite surprising. I mean, the bar is really low.
Yeah. We have, what if the employee was denied due to quitting a job over a year ago and has had substantial employment since the place they quit?
So it is the case for unemployment benefits that you can be denied if you quit without good cause from your last or next to last employer. So that is an issue for regular unemployment benefits. But I mean, it really is going to be a very fact dependent question whether or not you quit without good cause. But then the issue, as we talked about, is, if you're applying for PUA and have PUA eligibility, we're not so sure that denial for quitting without good cause should affect your PUA eligibility.
Right. And that if you are idled because of the COVID-19 crisis, you would be eligible for PUA.
But, and I understand the issue about having substantial employment since then. That is potentially, so a denial for quitting without good cause is from your last or next to last. You're then disqualified until you have 10 weeks of employment, and you make over your weekly benefit amount. So there is, it is of limited duration, but, it is last or next to last employment.
And the 10 weeks, does that start from your next to last or the most recent one?
The denial.
Yep.
So I don't know, David, I feel like the lost wages assistance, I don't know if we need to circle back and just make it clear that Nevada has applied for the additional $300. It is true. You have to have a benefit amount of at least $100 to qualify for that. We're not aware if Nevada is going to kick in the additional $100, and none of this has been approved at this point. So hopefully that kind of clarifies some of the questions that appeared to be about the lost wages assistance that we might have confusingly addressed.
Okay, that makes no sense, but oh well. You would think if you get more than $100, qualify for more than $100, you wouldn't get that assistance. It would go to the very low income people and not the people anyway, whatever. Where are you finding these rules, by the way? Because I just saw like a newspaper article, like
Yeah, that was the
governors.
internet.
Well, we'll see what happens. You know, you have hurricanes right now in the Gulf of Mexico, and that disaster assistance, that FEMA money. You know, it's like, who needs it more? It's just.
Well, we will stay on for another minute or two if anybody has any additional questions. But like we said, please feel free to give any of our offices a call to see if we can help you further. And as we've said, there are some very specific, fact-specific questions that are not appropriate for this forum. So please give us a call if we were not able to address your question.
We did just get one in saying, so in my case, it said I was approved for PUA, but all my weeks say in progress, but the section of unresolved issue, but then it says that there is an unresolved issue. What does this mean in the claim when there's like an indication of whether or not the claim is under review, it says no?
Yeah, so we've been seeing that a lot, where there's like some sort of issue that it's stuck in what they call adjudication. So the first step after you apply is an adjudicator reviews your file to determine whether or not you're eligible. We have a lot of untrained people that are reviewing these claims at this point. So there are issues where, there are no determinations being made. They're just flagged as unresolved issues. Usually you can go into your online portal and click on it and see what the unresolved issue is. Sometimes that doesn't help or doesn't make sense or isn't really coming up with anything. And then that's what we're talking about when we're saying that one of those common issues is that people are applying and not getting any essential, notice of denial or approval. And, there are the Supreme Court has indicated that 7 weeks is too long to wait for benefits you're entitled to. So that's kind of what we're talking about when we're talking about where do you go from here and needing to file potentially a petition for writ of mandamus against the Employment Security Division.
Then we have, what if I was in the process of transferring with my company to a new region right before COVID? Do I qualify for PUA? Was not eligible for UI for 2020 quarter. I work for Uber.
I mean, again, fact specific. So just in general, if you were unable to transfer to your new location because of coronavirus, that is part of PUA eligibility.
Yes.
Then we have, for gig workers and musicians who cannot get work right now, must that person be able to show gig income before COVID to be considered quote unquote employed before COVID?
So you do have to, again, as we said, there is a baseline level. You have to show employment in order to be eligible for benefits. But if you're eligible for PUA, there is a minimum benefit amount. Like I said, it's like $119 or maybe $190. It's based on the calculation of what the average regular UI minimum claim amount is. But you do have to show employment and wages in order to support a claim, but there is a minimum PUA benefit amount.
You basically have to show net income too, which is kind of odd because gross income is insufficient. Net income is what the Department of Labor thinks you need to supply.
But I mean, technically speaking, you can still qualify for the minimum benefit amount if you can show that you had employment, right. Self-employment, whatever it is. And it is a self-certification. So, you are self-certifying that you had whatever income you can support. And as they said, as we talked about in previous live streams, that they're looking for tax returns. They're looking for tax returns from 2018, 2019, even specifically 2019. Any, basically any information that you have, if you have profit and loss, whatever it is, to substantiate your wages. Otherwise, you're looking at the minimum benefit amount.
We have, if a person was mislabeled as a 1099 but should have been a W-2, how would they include their employment information for UI? It seems that they didn't consider one employer.
So for regular UI, what happens is there's no self-certification. So you apply for regular UI, you say you're an employee, they go to your employer, and if they're a covered employer, that employer is required to report your wages. If that employer does not, you can substantiate that by submitting information to the unemployment office. They're still gonna verify that information with the employer. But if you can argue that you are an employee, I mean, I think you can file a claim. I mean, there's also PUA eligibility if it's dicey.
And then we have, my funds are in my UI account and I get approved weekly, but my card is closed, so I can't get my money.
It's always something.
I know that there's that special email and phone number for the card issues. But I mean, that seems like a technical problem that should get resolved.
It should, yeah.
It should, right?
Yeah.
Do we have I'm Googling it right now, but do we happen to know the phone number? Let's see. That we can at least give. Is it through Bank of America?
Yep.
Okay, so Bank of America has a phone number for their Nevada Unemployment Insurance Debit Card Customer Service Center. It is 888-339-8569.
There's also an email address.
Yes.
It's on there. It's prepaid.bankofamerica.com/Nevada UI debit card /program/contact.
Okay. That is it for the new questions.
Well, thank you all for sharing your stories with us and tuning in. As we said, please feel free to contact any of our offices if you have additional follow-up questions that you would like us to address. But I think that will do it for today. Thank you, David.
Thank you.
Thank you, Ashley.
Thanks, you guys.
And again, thank you guys for joining us, tuning in to our live streams and our YouTube channel. We will see you next time.
Signing off.